Before I invite Judge Cantrell to come up and begin the story in the Chancery Court, we have a short video of Mr. John J. Hooker describing the judge who would actually hear that case for the first time in the Chancery Court.
Tom Steele was first of all, a decent, good man. He came from good stock. His father was a very prominent lawyer. Was appointed to the Supreme Court of Supreme Court of Tennessee. Died on the way home after he'd been sworn in. Never served a day, but he was highly regarded. And his son, Tom Steele, grew up learning the law from his father, and he loved the law. He did to the day he died. He was very knowledgeable, a real student of the law. And he was appointed to be a chancellor when he was a very young man, in the early 30s. Frank Clement, who was the governor of Tennessee, who was likewise a very young man, appointed him chancellor here in Nashville. And Tom Steele decided this case of Kidd versus McCanless, notwithstanding the fact that Clement had appointed him, and that Clement was a very popular governor at that time, and was very much committed to the rural interest. He had been tremendously successful in the rural counties, a great speaker, Clement, and so when Tom decided this case, the effect of which was to enthrone the power of the urban areas to receive their fair share of the revenue, this was detrimental to the political circumstance in which Clement was involved. But Tom did it anyway, and I think with his heart in his throat, because he didn't want to disappoint Clement, who had appointed him. But he was an honest man. He saw it the way he saw it, decided it like it was, went to the Supreme Court of Tennessee, and of course the Supreme Court couldn't wait to throw him out on the basis that the decision was a political decision, that the legislature had the ultimate say about it, and if they wanted to be malapportioned, there wasn't anything that the judicial system could do about it. Tom saw it otherwise, and so said, and the germ of the idea that he advanced in Kidd versus McCanless ultimately became a part of Baker versus Carr, which changed the whole circumstance in America.
All right. Have to ask the director of this program. In the mid-1970s, I was the judge of Part 1 of the Chancery Court of Davidson County. And one summer Saturday, I happened to be in St. Louis, and as I was wandering around Saturday morning waiting for the ballpark to open, I wandered into the old federal courthouse, which some of you may have visited in St. Louis down close to the waterfront. And I wandered into there and discovered that in the courtroom there was where the Dred Scott decision had been tried. And naturally I was impressed and a little awed to be at the exact location, arguably, where the first shots of the Civil War were fired. I remember reading somewhere that what President Lincoln said about Justice Taney, who had written the opinion for the Supreme Court, and he said, "Old Taney's the one that started this war." And so I was impressed by the fact that I could go there and be in the location where that case had started. On my way home, I thought you could say that about a case that started in Nashville. One of the first shots in the monumental struggle that resulted in the ultimate decision of one man, one vote was fired in Nashville, Tennessee. In fact, in Part 1 of the Chancery Court of Davidson County. I was aware that a case style Kidd versus McCanless had been tried before Chancellor Thomas Wardlaw Steele in 1955, seeking reapportionment of the state legislature. We are fortunate to have a prime source to talk about that case. You've already met Macklin Davis, who was in the legislature in 1954-55, and also was one of the lawyers who made the first effort for reapportionment. So Mac, take us back to 1950 when you got out of law school. Where did you start working? What firm did you go?
The name of it then was Armistead, Waller, Davis, and Lanston. the Davis was my Uncle Pascal, George Armstead, and William Waller. Tommy Osborne and Lawrence Dortch were the two associates they had, and that was March 1950.
All right, so how many lawyers were in?
There were
Waller?
6, but there were actually 4 partners and 2 associates who were Tommy Osborne and Lawrence Dortch were the 2 associates.
And then you joined.
And then Hunter Armstead, who is now deceased, in my class in law school, was with me in that when we got together.
So the firm now known as Waller.
Waller, Lanston, Dortch, and Davis. I think we have 163 lawyers, and we had something like, when we came, it had 6, and we made it 8. And there weren't 163 lawyers in Davidson County.
I was going to ask you how many lawyers were in Davidson County in 1950.
Yeah, but the politicians kept passing so many laws that they had to get a lot more lawyers.
Well, what kind of practice did you do?
Everything.
You told me about one of your first cases, may have been the first one, where you were called on to evict a widow with 5 children.
Right. Guarantee Mortgage Company was one of our biggest clients, and they sent this case up to file a suit to throw a widow who had 5 children out of her house because she hadn't paid her mortgage and defaulted in it, and they wanted to sell it. And naturally, since I was the youngest guy in the firm, they gave me that case because nobody else would do it. And I get over there before Judge Brown Taylor, and the lawyer for this widow was Thomas O.H. Smith, who had been superintendent of Sunday schools at Christ Church, where I had gone all my life. I was really embarrassed. But things turned out great. He said to the judge, "Judge, I've got a case somewhere else this morning. I can't try it. We'll have to put it off." And the judge said, "Okay, continue it for 3 weeks." And I sure was glad. And in the 3 weeks, she left with her 5 children. The widow did. But that was my first time going to court. I didn't like that one very much.
Were you interested in politics?
Oh, yeah. I was. And in 1954, I ran for the state legislature in the Democrat primary. And everybody was a Democrat in Davidson County. They didn't even I got elected in the Democrat primary. I was number 6 out of 6 to be elected. I had the 6th most votes. Doug Henry was elected. He had a lot more votes than I did. But then, now, when I got up there, I introduced a bill to reapportion the legislature required by the Constitution every 10 years.
Well, before you get to that, let me ask you one other question about the election. You were 6.
Yeah.
And we've heard that Judge Lester was maybe 7th.
Yeah.
Who else was close?
Cornus Phoenix.
So Mr. Enix, I remember him,
Yeah.
a very engaging African-American lawyer.
Right.
And so if Davidson County had had the proper number of legislators, he perhaps would have been
elected. Yeah, we
the
were
first
entitled
African-American elected.
We were entitled to 8, and we only had 6. And Shelby County was entitled to 9. They only had, 12, and they had 8. But Shelby County, I introduced a bill. I thought I'd never get a bill passed doing the correct reapportionment, but I introduced one that gave, I looked at, and it changed about a 20% increase toward correct apportionment. And I had it devised so that if every representative of a county that was helped by it voted for it, and the representatives from counties that weren't affected one way or the other would vote for it, I'd get 60 out of 99 votes. But the Democrat Party bosses told me to withdraw that bill on second reading.
Who was the Speaker of the House, if you remember?
Jim Bowman from Shelbyville.
All right. Is he the one that approached you about your bill?
Yeah, one of them. And I said, I can't. I took an oath to support the Constitution. Nobody can vote to reject it. I was wrong.
So
The party had more influence than the Constitution
so they
did.
tossed it out on second reading.
Right.
Have you ever known that to happen before or since?
I think it was the only bill that was thrown out on second reading when I was up there. I don't remember any others that it ever happened to. You're supposed to have the vote of it on third reading, and when somebody moves to do it on second reading, and that's very rare.
Well, I'm glad you brought us up to 1954. Governor Clement had just been elected to the first four-year term, and the legislature, as we've heard, only met every other year. And so a young lawyer like you could serve in the legislature and not take too much time away from his practice. Why did you decide not to run again in '56?
I figured after I had gotten so much on the bad side of the Democrat Party when I was in the legislature that they would see that I got beat the next time. And I just came out 6th out of 6 anyway, so I couldn't spare any votes.
Well, I noticed that the case of Kidd versus McCanless was filed in the Chancery Court on March the 8th of 1955. I noticed also the handwriting of that dear lady who served in the Chancery Court, Clerk and Master's office so many years, Miss Emily Lord,
Right.
who enrolled the complaint. Would March the 8th have been about the time that your bill had been booted out by the majority in the House?
Probably around there.
And it was filed by, signed up by Tommy Osborne, who was the leading lawyer. What had Tommy done in the intervening years after your association with him at Waller?
Well, he had been city attorney, and I forget the years, but he was over there for 2 or 3 years, I think. And he was a leading trial lawyer in Nashville. Had lots of cases, all different kinds.
And I noticed that he signed as counsel on the complaint from the law firm of Barksdale, Hudgens, and Osborne.
Right.
So he had left the city attorney's office. And
Yeah,
gone
when he
over.
did that, he didn't come back to Waller, Armstead, Waller, Davis, and Lansing, where I was. He formed his own law firm with some other lawyers.
I also noticed that the complaint alleged that the plaintiffs were now denied the right to equal suffrage in free, equal elections, which right is granted them by the Constitution of the state of Tennessee and the equal protection of the laws as guaranteed by both the Constitution of the state of Tennessee and by the 14th Amendment of the Constitution of the United States.
Right.
So it wasn't
Wasn't any question about it.
wasn't simply based on the Tennessee Constitution,
Right.
but it was also based on,
Well, that was so it could go to the federal court if we lost in Tennessee.
which, what did you anticipate?
Well, I didn't anticipate because when I introduced that bill in the legislature, the party bosses, Democrat party bosses, told me to withdraw that bill immediately, that the party didn't approve it. And it's very political, and so I should withdraw it. And I said, I can't. I took an oath to support the Constitution, which requires it. And I said, nobody can vote against it because they all took the same oath I did. And of course, I was wrong about them not voting against it. Shelby County, who would have profited the most by reapportionment, had 8 representatives, was entitled to 12. Davidson County had 6 who were entitled to 9. All Davidson County delegates voted for the bill, but all 8 Shelby County voted against it, voted to reject it on second reading, so it got rejected on second reading.
I also noticed in looking at the complaining Kidd versus McCanless, that your name was listed as of counsel, but it had been crossed out. You didn't sign it as of counsel. Do you remember
Well,
what the circumstances were?
because as soon as the bill was filed, they filed a counterclaim making me a defendant to the counterclaim. So I didn't think I could be a lawyer for the plaintiffs and still the lawyer for the counter defendant. So
Somebody filed what we call then a cross bill,
yeah,
and named all of the members of the House from
Right.
Davidson County,
right.
which we've heard who they were. We've
Yeah.
seen some of them today. And
Right.
you filed an
Doug
answer.
Henry and Ward DeWitt were,
You filed an answer on behalf of the delegation,
yes,
and you sought the same relief that the complainants did.
yeah.
That the court order reapportionment.
We didn't get it.
What was the result? Well, let me ask first, how well did you know Chancellor Steele?
Well, I knew him pretty well because they had a band called the Lawyers Band, and although I'd known him even before then pretty well, he was the drummer in it, and I played one of the saxophone players.
I remember that band, and in its later history, it was known as the Public Offenders.
Yeah, right. Public offenders probably named.
Yeah. And I think you told me that the doctors also had their own band about that
Yeah.
time. Is that correct?
Yeah, the musical maniacs or something like that. Musical medics, they call them.
Well, there was a record made, I
Right.
think, that was titled Jawbones versus Sawbones.
Right, Lawyers Band on one side, the Jawbones, and the Sawbones, other side was the doctor's band.
Who else was in the band?
Well, Tom Steele was our drummer. Larry Richards of the title company was a lawyer. And he was a real good saxophone player. I wasn't, but I sat next to him. Bobby Lewis, who'd been, Brandon Lewis was his name. He was a saxophone player. Dan McGugan was a saxophone player. Don Hildebrand was a saxophone player.
And I believe Judge Lester was the vocalist.
Yeah, he was our singer.
I see. Okay, so you knew the chancellor pretty well.
Oh, yeah.
We know that you faced a big problem in this effort because of the separation of powers
Yeah.
and the idea that the courts couldn't tell the legislature what they had to do.
Yeah.
And as I recall, the case was decided on demurrer. I mean, all of the defendants had demurred to the bill, and at that time, after the chancellor ruled on a demurrer, that was automatically appealable. Is that correct?
Yeah, if he sustained it, and because that ended the case. But he ruled, Chancellor Steele ruled right. He ruled for us, and they, then in that case, the appellate courts had the discretion to grant an appeal, which they did. And so that's
And it went automatically to the Supreme Court,
of
as I
Tennessee,
recall.
yeah.
And a case where the lower court had overruled a demurrer that went directly to the Supreme Court, as I recall.
If they had a discretion.
All right. Can you tell us the mood of the plaintiffs while the case was pending before Chancellor Steele?
Well, they were strong Democrats, and the Democrat Party liked the way the present apportionment was, and didn't want to have to change it. I never got the reasons.
What was the expectation of the lawyers, and particularly you and Tommy Osborne?
Oh, well, except for the fact that the chancellor was Tom Steele, who had just been appointed by the governor and fill a vacancy, and we didn't know how he'd vote on this, but I had confidence in him, and he ruled right. He ruled in our favor, and they appealed.
So he overruled the demurs, and they took it up. How did he handle the problem of ordering the legislature to do something?
Well, he ruled that the act is unconstitutional. I don't think anybody really seriously thought it wasn't, but in any event, he said it was up to the legislature to rule correctly, make a correct ruling, and I think he was absolutely right in that, and he presumed they would, but they didn't.
And as I recall, he said that the act was unconstitutional and the legislature was not constitutionally formed.
Yeah.
What about all the acts they had passed in the 40 years?
Well, they were de facto officials, and it wouldn't affect that because they were in there. They got elected according to the election procedure, and hadn't been ruled unconstitutional at that time. But back in those days, people really, the majority of people seemed to be against technicalities like constitutions, particularly the Democrat Party. And there were no Republicans around here. There were some in East Tennessee, but they didn't have much influence. Like when I ran for the legislature at 54 and came in 6th in the Democrat primary out of 6 that got elected, the Republicans didn't even run anybody against us in the general election.
I've been through that in Davidson County.
Yeah, right.
I have to say also that I practiced law with Tom Steele later. I thought he was one of the finest trial lawyers in Davidson County,
And a great judge.
and he was, and I'm not surprised that he did what he did. What did the Supreme Court do?
In which case we took that
In Kidd versus McCanless?
Kidd versus McCanless.
After you won it in the Chancery Court.
They reversed it. I don't remember exactly what their excuse was. I think they said that the court didn't have jurisdiction to determine the issues that it was determined. Okay.
So it was a political thicket that the courts weren't going to get into.
And then that exhausted the state remedy, and the case of Baker versus Carr was filed in a federal court.
All right, Mac Davis, everybody. Let's give him a hand.